All right, thank you, and welcome everyone. We appreciate spending your lunch hour with us to discuss several issues that impact financial institutions in patent litigation. Before I get started, there are some housekeeping matters and announcements that I want to communicate to everyone. First, as we go along, there is the opportunity to ask questions via the webinar, via the website. It should be, I think, in the top right corner. We'll save questions for the end of the webinar, and hopefully we can address. As you'll see, we packed a lot in to try to accomplish in an hour, because we wanted to at least present to everyone what we think are the critical issues that are facing financial institutions in patent litigation as we head into 2017. If for some reason we run out of time and we can't get to questions, we're happy to talk to folks after the webinar at your convenience. And we'll also be, if you request, we can send the PowerPoint presentation to you so you have that. We did intend to have the PowerPoint be a little bit more comprehensive than we thought we could accomplish in an hour, and that was so we could send it to you and you'd have that information handy. But we are going to endeavor to work through and get through all the items that we want to discuss. Also, I know front and center in most people's minds, you are receiving CLE credit for this, and there will be a code that I'll read as we get halfway through the presentation, and then will be another code at the very end. So just look for that, and you'll need to jot that down in order to get CLE credit. Let me go ahead and introduce first. My name is Steve Baskin. I am in the Washington D.C. office. I am the managing partner of the IP group in D.C. We've got distinguished panelists with us: Bill Barrow, Derek Rolanchek, and Sakib Siddiqui, all involved in representing financial institutions in patent litigation matters, and have been involved in the issues on a day-to-day basis that we're going to discuss today. Just to tee up what we'll be talking about today. The first thing, Darryl will be talking about Section 101 and starting with the kind of the evolution of Bilski and how it's transitioned with the Supreme Court decision in Alice, and then some follow-up recent Federal Circuit cases, in particular EnFish, that people are focused on in thinking that there may be somewhat of a sea change with 101 following that decision. The next topic will be the covered business method patent review in the Patent Office that came about as part of the AIA that was enacted a few years ago, that is specifically directed towards financial institutions. And there's been some recent developments with the jurisdictional requirements, amongst others, that I think everyone will find interesting. The third, I'll talk about the data treasury litigation. There's been some, believe it or not, those that were involved in this back in the early days of data treasury. There actually have been some recent interesting developments, and it's actually also a nice tie-in with the 101 issue and the CBM process, because those, particularly as we're discussing them today, the CBM process didn't exist in the beginning of data treasury when those suits were filed, and 101 looked a lot different, certainly. So we'll talk and just kind of put it into context for data treasury on the 101 and CBM front. Bill will talk about some recent Federal Circuit cases, mainly dealing with joint infringement, some recent willfulness decisions, HALO, and follow-on cases, and attorney's fees as well. And we'll also kind of wrap in some discussion on indemnity provisions, which are very important and people are focused on, certainly when there's third-party technology, which a lot of the times with financial systems that are accused, they come from third parties. We're going to try and get with a legislative update, and we'll keep this somewhat political neutral, as we don't know what may happen in terms of focus on IP with the new administration, but there is some pending legislation that will apprise everybody of as well. So with that, I'm going to hand it over to Dara to talk about 101 and Alice.
Thank you, Steve. So yeah, as Steve said, I'm going to be talking a little bit about Section 101 of the patent law, which is really a threshold issue that defines what is patentable, what you're allowed to get a patent on. And that's what's new and useful, whether it's a machine or a process or a way of making something. But what it can't be is an abstract idea or something that occurs naturally in nature. And this is such a kind of basic threshold issue, was not receiving a lot of attention for a very long time. But then recently, the Supreme Court came down with several decisions addressing 101 that have brought it to the forefront of the patent analysis process. So what first came down was Bilski in 2010, which dealt with a patent that addressed basically the hedging of risks. And that patent specifically applied that concept to energy markets. And the Supreme Court analyzed this patent and said that, hedging risks is an abstract idea that's been out there for a long time. And just taking an abstract idea like that and limiting it to a specific field of use does not make that patent eligible. The Supreme Court then came back in 2012 in the Mayo case and looked at another patent having to do with calibrating dosages of the drug. And when they looked specifically at that patent, they found that they were describing using routine practices that researchers use in that field to do calibrating all the time. And they were using that to manage the application of a drug, but that was really just measuring a natural chemical relationship and a chemical reaction that was happening. And so taking something that was a well-known concept and just applying that to measuring something that occurred in nature was also not patent eligible. The third time recently that the Supreme Court addressed 101 and eligibility, and what has really become a major focus in patent law recently, is the Alice case. And from that case, we came out with the concept that abstract ideas cannot be considered patent eligible simply by implementing them by using computers. This case specifically dealt with claims for using a third party to mitigate risk during a settlement using an intermediary. And the court found that that concept of using a third party to mitigate risk, like a clearinghouse, was an abstract idea that had been in existence for a long time, and just implementing that over a computer did not mean that it was patent eligible under 101. So these cases have been the focus of a lot of litigation, and there's a new framework that has come forth that the courts have really been paying attention to. And there's a two-part test that's being used. And that is that first is to determine, is this a patent ineligible concept? Is it abstract in the idea? Is the basic thing that's being performed when it's boiled down abstract? And if so, looking to see if there's a meaningful limitation added by using a computer. Are you doing something to the abstract idea? Is the way that you're doing this new, or are you really just using the computer to make it faster and it's not new? And so this analysis has really come forth in a lot of new opinions. You can see that there are some statistics here on this slide that show there have been a number of 101 challenges filed since this Alice case has come down. And in using this test, it's been very successful in invalidating a large number of patents and claims. So as these cases are running through, we're seeing several issues that we're watching out for that the courts continue to look at. First is what actually qualifies as an abstract idea. And courts have been taking the idea of what's going on in the patent claims and distilling them down to their most basic nature. But how far down you're able to distill that is still a question that the courts are addressing. The second part is looking at what's considered conventional or routine in a specific field that's being addressed. And the courts are still deciding how much other information and outside information they're able to consider when they're determining what's routine. So as I mentioned before in the Mayo case, I mentioned that they were using a routine way of calibrating and measuring a drug dose. How much information are they allowed to consider, and how much prior art are they allowed to consider? As many of you know, that there are other sections, 101 and 102, where prior art is the main focus of those sections in determining ineligibility. And in this case, the courts are still determining whether or not there should be a distinctive test under 101 or whether those tests will become overlapping if they allow prior art to be considered in the 101 analysis. So I'm going to talk a little bit about cases that have come down since Alex. We're going to focus a little bit more on what's more recent, but when Alex first came down, there was a flurry of challenges under 101 to computer-related patents and software-related patents. For example, there was the content extraction case back in 2004 that dealt with data collection, recognition, and storage, and the court found that to be abstract because they were just using those old abstract ideas and using a computer in a generic way to make it go faster, but not adding anything more to it. Similarly, in the Shortridge case in 2015, there was just cataloging data, and that was on the computer, and no additional steps were added. And as I'm sure some of you who are on here remember, the intellectual ventures cases, there were additional there were additional findings of ineligibility under 101 for patents based simply to the concept of budgeting or manipulation of data and mobile banking. What's been really interesting recently, in 2016, the Infish case came down, and it was the first time that the Federal Circuit came out and kind of swung back the other direction, kind of giving hope back to software patents that it is possible for computer-based patents to be considered still patent eligible. And mainly what happened here was that there were claims directed towards logical models for computer databases that explained how various elements of information can be related. And though that itself can be an abstract idea, the court found that the way that they were performing this by using the computer was new and patentable. And the idea was that the improvements to the computer-related technology are not inherently abstract. The court said you should look at the specific improvement, and if the computer functionality causes an improvement, as it was in this case, then it can still be patent eligible. Since this came down, there's been a swing in cases in finding that there are computer-based patents that are still considered patent eligible under 101 and have survived 101 challenges. So in June, there was the Bascom case, which claimed that content filtering system was found to be abstract, but the court found that the way the filtering system was installed and used on the computer was novel. They cited back to Infish, and they said that the way the computer functioned contributed to that improvement, and it was not just using a computer generally to implement an old idea. Similarly, in September, the Federal Circuit came down with the Micro case, which dealt with 3D lip sync automation patents. And while lip sync and automation existed previously, they found that this concept and what was claimed in this patent contained patent-eligible subject matter because it provided a specific approach that any regular animator in this field would not have used. So again, eligible subject matter based on the way it was implemented with the computer. Now, there have been cases where they have found the other direction, and in October, the fair warning case, the Federal Circuit found that the tracking of user information, activity, and compiling that information to analyze it was an abstract idea, and the way that they were implementing it using a computer was not novel. This was just an old practice in a new environment, and so they referred back to Alice on that. In November, the Federal Circuit again addressed this issue. This one dealt with a counting method, and while the district court had found the patents were ineligible, the Federal Circuit actually reversed that and found that there was eligible subject matter. This was similar to the fair warning case. Even though there were normal generic components used to implement the accounting method, they found that they used those computer components in an unexpected way to improve the function of the computer. And because of that, it was patent eligible under 101. There have been a number of other cases, but one other one I wanted to highlight was the Rothschild case that just came out last week, and it found that there was eligibility for this case. What was important was that the Federal Circuit, or the Eastern District of Texas, rather, was interpreting the Federal Circuit and noted that INFISH does not stand for the proposition that an improvement to computer functionality is always sufficient to satisfy the first step of the Alice test. What's important is that the claims are to be considered as a whole in order to evaluate what they're directed toward and whether or not it's an abstract concept. This new test of Part 1 and Part 2 isn't as important as really looking at overall what's being claimed and how it's being implemented.
So, Dara, real quick, quick question. Some are saying that NFISH may create a sea change in terms of how we look at 101 when defending against patent allegations, patent infringement claims. Do we have a sense yet? Can we project at all whether that is the case based on the cases that have followed NFISH, or are we still kind of waiting to see how it all plays out?
I mean, it certainly is having an effect, and we'll see as the cases move forward, but there have been a larger percentage of cases in the Federal Circuit now where 101 eligibility has been found for computer-related patents than there have been prior to NFISH coming down, and that's certainly been a large result of that case. And as these cases continue to move forward and it's interpreted by the district court and clarified by the Federal Circuit, if they stay on this path, I think we'll see that it is something that definitely needs to be taken into consideration and looked at a lot more closely when defending against these software and computer system patents that can be asserted.
Okay, thanks.
The other way of challenging these types of patents, other than going through the federal court cases, is to go through the PTAB at the Patent Office. They've implemented a covered business method review, which is the one review method that's been allowed where 101 challenges can be heard in front of the Patent Trial and Appeal Board. And you can see here a chart showing some of the statistics on the trials instituted. The CBM process, I'm going to have Sakib here dive into that in much more detail, but you can see that overall having these Supreme Court cases come down and both the Patent Office and the federal courts interpreting and using these to analyze patents under 101 has really caused a huge wave of challenges and changes in the way that we're analyzing these computer systems and software patents. So I'll hand it over to Sakib so he can give you a little more detail on the covered business method review.
So the covered business method review, or CBM review process at the Patent Office, it was born out of Section 18 of the AIA, and specifically it was a result of a lot of litigation, controversial litigation on by NPEs using patents that were, covering generic business method type approaches. For example, in the legislative history of the AIA, and when this Section 18 was being discussed, there's specific mentioning of the data Treasury cases and how that kind of patent practices were not, were not supposed to be the purpose of the patent statute. So they passed this transitional program, which is that you can go back to the Patent Office for issued patents and challenge the patentability of those patents based on 101, 112 prior art, and still not have the same estoppel effects as an IPR. And you can only bring a CBM challenge if you have been sued, so you're in litigation, and there's several requirements, standing requirements that you need to meet. So what is a covered business method patent? So the first step you need to do is you need to say it needs to be a method or apparatus that performs the data processing or other operations or used in the practice, administration, or management of a financial product or service. So that's the first step of the CBM eligibility test. You convince the PTAB that this claim is directed to a financial product or service. Once you've established that, you perform a second step, which is you determine whether those claims are directed to a technological invention. So, for example, the claim could be directed to a financial product or service, but is it then implemented in a technological invention manner where it's new or novel? So then you won't be able to qualify for CBM eligibility. Traditionally, and as the legislative history comments indicate, the statute was supposed to be interpreted broadly, and so there's a specific comment in the legislative history that says that it's drafted to encompass patents that claim activities that are financial in nature, incidental to financial activity, or complementary to a financial activity. Using this, the PTAB had been using this language in all of their CBM eligibility decisions, and had a really broad understanding of this concept, or we're qualifying a lot of patents under this, finding them that for being eligible for CBM review. So this is an example of a case of a PTAB proceeding where the Patent Office found that this claim was actually eligible for CBM review. And you'll note, I mean, I know there's a lot of text in this claim, but like basically the key points highlighted are the claim just talks about storing data in the encrypted data element values, storing data in a second database, and controlling access to that database. So it's really talking about how you safely, securely store data in a database. Nowhere in the claim was there any mentioning of a financial product or service, but the specification of this patent talked about using the claimed invention in other fields such as industry, banking, insurance, etc. Because of course banks require, it's really important for banks, financial institutions to store data in a secure manner. Just using that hook in the specification, the PTAB found that this claim was eligible for CBM review because it's incidental or complementary to a financial product or service. Now, this exact issue was sort of addressed recently by the Federal Circuit in Unwired Planet. I believe the decision came out on November 16th, I believe, and it was very interesting because it sort of brings about some uncertainty in all the CBM challenges that have occurred so far and that have been filed currently. Basically, what the Federal Circuit held over there was that the PTAB made a mistake in relying on the incidental or complementary language when evaluating whether a claim satisfies the CBM eligibility prong. Specifically, the claim of the Unwired Planet patent related to providing location information for services based on the authorization included in a user profile, and the claim did not talk about any financial product or service, but the specification talks about that claim being applied to the sales of goods or services. So the PTAB used that hook of the specification and said this claim is eligible for CBM review. So the Federal Circuit said that the PTO has not used its rulemaking authority to adopt the incidental or complementary language into the statute, and the proper inquiry going forward should be based on the language of the statute itself, not whether the claim is incidental or complementary to potential sales, or also the PTO should not look at, the proper inquiry is not whether the specification speculates that a potential sale might occur. There was some discussion in the Unwired Planet decision on, you know, at some point every claim is related to a sole good or service, so it's very interesting that the Federal Circuit found out this way. Now, district courts do construe statutes in view of legislative history all the time, so this wasn't something that the PTAB was doing that was unique, and so this decision is a bit sort of different in that way, that it completely just undermines what the PTAB has done so far in all the CBM eligibility decisions. So, and it also is inconsistent with the holding of Blue Calypso versus Groupon, where the PTAB affirmed a CBM that was filed, that was held by the PTAB for an invalid claim, for a claim that was directed to a financial product or service, in which the Federal Circuit itself, in the opinion, refers to the incidental or complementary language while affirming the PTAB's decision. That was a different panel in that case as opposed to this case, so there might be an issue there. There is a possibility of maybe seeking en banc review to sort of reconcile the two decisions. At the Patent Office, the result of this decision, basically right now, there's a lot of doubt in what's happening in the current proceedings. So what we are seeing is the PTAB itself allowing the patent owners and petitioners supplemental briefing of 4 pages to address why certain claims are still eligible for CBM review in view of this new standard. It's uncertain what will happen if there's CBMs that are instituted under this narrow interpretation of unwired plan-in, but then if en banc review finds out that what the PTAB was doing all along was right. So there is definitely some uncertainty now caused by unwired plan-in. The second prong I just wanted to address real quickly of the CBM eligibility test is basically whether the claim is directed to a technological invention. That has remained unchanged from unwired plan-in. That basically just says if you have a financial product or service and you just implement it on known technologies such as general purpose computers or software, and you don't really change the method or system to something novel, then you're still eligible for CBM review. And the CBM supposed to, this transitional program is scheduled to end in September 16, 2020, so you can file petitions up to that point, but not after that point. One avenue to continue challenging claims under 101 at the PTAB is using the post-grant review PGR proceedings, which lets you challenge patents based on 101, 102, 103, and 112. This is only for patents that are filed on or after March 16, 2013, but this PGR proceedings really is for situations where you're sort of monitoring your competitors' patents, because you can only really file it 9 months after a patent has granted or issued. So it's not really a complete replacement for the CBM. It's just another avenue where you can challenge patents based on 101 at the PTAB. There's not really been a lot of serious discussion yet on possibly continuing or extending CBM beyond the sunset date of September 16, 2020.
So next, real quick, so it's important as we have some time, but not much. September 16, 2020 will be here before we know it. So if we're in litigation and we believe that the patents are directed to financial services, to the financial services industry product system, as we get closer to that date, it's going to be real important to file those petitions before September 16, 2020, right?
That's correct, yeah. I think we're going to see a surge of filings right before that. That's sort of like, I think we saw a surge of filings before in district court litigation before that the new rule changes went into effect.
All right, and just for the audience, I mean, this is something that we are paying careful attention to in terms of reviewing, any public information that is associated with the CBM process, and in particular, paying careful attention to whether there's any discussion or reference to possibly extending that program. We haven't found, we haven't seen anything, and we still have a few years, but we haven't seen anything as of yet to indicate that it would be extended. So that September 16 date, 2020, is important for the filing of CBMs. Real quick, I want to go through the data treasury. I was involved in the early cases, and I know others on the phone were as well. So I'll refer to it as the data treasury saga. It was in the beginning of time of the NPE, the patent trolls, for the most part, and Eastern District of Texas, that was starting to become the hotbed for patent litigation, and didn't know a lot about the judges, certainly as much as we do now. in how they were going to treat and react to patent litigation, although we did have a pretty good understanding that the judges were going to be patent owner plaintiff friendly and that the juries would be as well. So those factors that we always take into consideration in any court, but in particular in the Eastern District of Texas, and that was back then, and that certainly hasn't changed now. So Data Treasury was a company, purported to be a company that had a prototype system. Claudia Ballard is the inventor of the two main patents, and started a company in 1998 out of New York. In 99 and 2000, Data Treasury received its two business method patents covering essentially check imaging technology, the technology related to systems that were internal processes of imaging checks and other documents and securing the data and getting it organized internally, and also involved remote systems, either from branches in a remote deposit capture system as well. The 988 and the 137 patents are the two Ballard patents. Again, they covered, remote data acquisition, centralized processing, and storage of the acquired data. Data Treasury alleged that the patents could read, again, upon check scanning systems that I just kind of referenced at a high level. In 2002, Data Treasury filed, back then it could be one lawsuit, so it was a single lawsuit with 20 defendants, or about 20, and it was the largest financial institutions in the, in the U.S. Back then, there was no CBM process, so a number of the defendants filed an ex parte re-exam with the Patent Office to try to invalidate the patents, and that process is much different than the CBM process. Once you file the petition, the petitioners are for the most part out of the process, and then the patent owner communicates directly with the examiner and with the Patent Office to try to convince them that the patents are not invalid. They retained experts, and in this case, Data Treasury retained a pretty well-known expert, and they were successful in the Patent Office not invalidating the patents in that process. As a result of that and other things, given the time and the era, it resulted in a lot of license agreements. In fact, everybody except for U.S. Bank settled, and when U.S. Bank went to trial, it resulted in the, what we had feared and thought in terms of the Eastern District of Texas. There was an award of infringement. The patents were deemed valid, and there was also willfulness, and total damages resulted in $53.2 million. Data Treasury, not surprisingly for those that were involved, weren't done, and they weren't content, so they decided to continue their quote-unquote saga and filed a second round of lawsuits, now against smaller banks and smaller institutions. Problem is that now the CBM process was available to these defendants, the problem being Data Treasury's problem. So those banks filed a CBM petition in October of 2013 on both patents. On April 29, 2014, the PTAB instituted review and then issued decisions invalidating the patents in 2015. And that was, for those that attended our seminar last year, that was one of the focuses, was a result of the Ballard patents being invalidated. I saw that, and I figured there was going to be a lot of people that went through those earlier cases that would be very interested to hear that the patents were invalidated and the reasons why. The PTAB in that CBM process found the claims eligible for CBM review, so they were directed to financial services. That wasn't too much of a surprise, and also that didn't fall under the technological exception. Data Treasury had argued hard on that exception and lost. The PTAB found the patents invalid under 101 and also under Section 112. So that is a good example of the benefit of going to the PTAB rather than certainly being in the Eastern District of Texas and having actual individuals that are familiar with the issues and that see them every day, able to look at issues like 112, for example, which are a little bit more, a little bit more patent technologically specific, and get really into evaluating and reviewing the patent claims and the specification. Data Treasury appealed. Again, they were very focused on the technological innovation. They tried to get it dismissed on jurisdictional grounds. They were unsuccessful, and the Fed Circuit affirmed the PTAB's decision in validating the Ballard patents. That wasn't the end. Data Treasury being a saga, there needed to be another chapter, and that chapter resulted in an interesting development specific to Data Treasury's second wave of cases that they filed against the smaller banks. And those were specifically settled, and J.P. Morgan Chase, in their license agreement, this is all public information, had a most favored nation clause that entitled J.P. Morgan to any and all favorable terms if Data Treasury entered into a license agreement with any other entity. That resulted in a refund of the difference, and it was a sizable refund, as you can see on the bullet, of $69 million. So the Fifth Circuit affirmed the decision by Judge Snyder out of Texas, and Data Treasury attempted to get the case in front of the Supreme Court, but they denied cert. So it's the reason why I'm just from the perspective of what we're talking about today. The 101 process and the CBM process has had, in Data Treasury is a perfect example, a direct impact on patent litigation and how patent litigation cases are handled, the strategy, and the Patent Office is now, specifically much more involved, able to be more involved in the process of reviewing the validity of patents through the CBM process based on 101 grounds, which is helpful. And so it's telling in that the Data Treasury case, which, as Saka mentioned earlier, was at least in part one of the reasons why the legislation was enacted in the first place, that those patents eventually were found and deemed invalid. So it's just an interesting development, and even though it's been some years, has just been recently, another recent occurrence with the J.P. Morgan case. Now I'm going to pass it off to Bill to talk about recent important federal circuit and federal cases. Go ahead, Bill.
Thanks, Steve. Okay, I think we're set. So I'm going to talk about some recent developments in a number of areas that are relevant to all potential litigants, patent litigants rather, in particular financial services companies, and then I'll use some of these topics as a segue into some more practical considerations. So first, I'll start with joint infringement, which I think is an area that all of us can use a primer on every so often. A lot of folks are probably familiar with the Akamai line of cases on inducement. In 2014, the Supreme Court weighed in and confirmed that an accused infringer cannot be liable for inducement unless a single party has directly infringed the patent. On remand, the Federal Circuit provided additional clarity on what constitutes direct infringement when you have multiple actors. First, to confirm what we all know as the direct or control or mastermind theory, which was articulated in the BMC case many years earlier. And then, of course, it articulated what it called the joint enterprise theory. With respect to the former, it basically confirmed that courts should continue to consider general principles of vicarious liability. An actor is liable for direct infringement if acting through an agent or contracts with another to perform one or more steps of the method. And again, that's from the Federal Circuit's 2007 decision in BMC. In the Federal Circuit's Akamai decision, they added the piece that when an alleged infringer conditions participation in an activity or receipt of a benefit upon performance of a step or steps of a patented method and establishes the manner or timing of that performance. And just as a quick example, a few weeks after this decision came out, there was a decision in the Southern District of Indiana where you had a patent directed to basically a method of administering a drug for cancer treatment. And so the claims required that the patient take folic acid, and then after that they would receive the chemotherapy. And the defendants in that case, which were generic drug manufacturers, they argued that they could not be liable for inducement because there wasn't a single actor there. You had steps performed by the patient and you had steps performed by the physician, and the court determined that the receipt of the chemotherapy was conditioned on the patient taking the folic acid. You couldn't have one without the other. And so that fits squarely within this new piece to the director control test articulated in Akamai. And then the court went a little bit further too and said that the physician was directing all the steps there. You know, he was administering this treatment. And so in that instance, it was determined that the defendants were liable for inducement. Turning to the joint enterprise theory, there are 4 pieces to that. And really this sort of dovetails with the direct or control test because this still relies on principles of vicarious liability. So the 4 elements are, 1, there's an agreement, express or implied, among members of the group. 2, there's a common purpose. 3, there's a common financial interest in that purpose. And 4, there's equal weight because, you know, this is a joint enterprise, so each member has, you know, an equal amount of control over the enterprise, so to speak. And in issuing this ruling, or this piece of the ruling, the court relied on the second restatement of torts for the principle that each actor is the agent of the other. So it's the same premise as the direct or control test. You have 2 actors and they're each liable for the other's conduct. And, you know, obviously at bottom, what this case determined was that all steps still must be attributed to a single entity for direct infringement, which of course is required for inducement. So using this to sort of, you know, address a more practical issue, you know, these joint infringement issues frequently come up in the context of the customer-supplier relationship. For customers, and typically in that scenario you have indemnification issues. For customers, they're going to need to take a look at any implicated supplier agreements to see if there's an applicable indemnification provision. Of course, this is often easier said than done. In fact, it is not uncommon to have cases proceed far along or even through trial without any resolution reached with respect to who will bear the cost for litigation. It's also critical for the customer defendant to undertake this analysis as early as possible. This can be difficult, however, because sometimes the patented technology may be complex. Complaints aren't always all that specific, and they can be vague, especially if the accused functionality is pretty complex. Of course, this may require the assistance of outside counsel, in which case, you know, for the customer defendant, they might want to go ahead and retain that counsel so that analysis can be undertaken as quickly as possible. Even if this analysis is completed and the customer determines that the supplier does owe an obligation to cover litigation costs or to hire counsel for the defense, there may be disputes, for example, regarding the scope of the indemnification clause. So perhaps the supplier only performs part of the claim method. In that case, you know, we're certainly dealing with a joint infringement scenario. The customer also needs to assess the extent to which its interests are aligned with respect to the substantive arguments in the case. Separate counsel may be desired, or even required depending on the language of the contract, and issues of state law as well as potential ethical issues may also come into play. So put simply, there's a lot to consider, both in the context of dealing with the indemnification issue, but also in terms of the preparation of those types of clauses in contracts. And so there's a lot that that potential defendants need to be cognizant of. And so we provided a couple of examples here. I'm not going to go through these in much detail, but we are going to circulate this deck to everyone so that they can take a look. But basically, we provided 2 exemplary indemnification provisions, and then we provide, you know, a few examples of some pitfalls here. And basically, the purpose of this is to show, you know, the devil's in the details, obviously, and there's just a lot of issues that can come up. Just as a few examples for the customer, you know, a lot of these clauses require that the customer provide notice. Obviously, you know, with these contracts, people, you know, have a tendency to copy and paste language, and sometimes they're not fully assessing the details of that language. So the customer needs to make sure that they're, you know, content with what's actually stated there, or whether they actually want to include a provision like that. And then, additionally, you know, for the customer, they want to make sure that they exercise the degree of control over the defense that they need, that they desire. And so, you know, it could be the case where the supplier insists on provision where they control, you know, all the negotiations and everything of that nature. And so this is something also that customers need to be cognizant of. Turning to the issue of attorney's fees, as most of you are aware, Octane Fitness broadened the standard for determining whether a case is exceptional for purposes of awarding attorney's fees. Basically, the Supreme Court rejected the framework from Brooks Furniture as overly rigid, as well as the requirement that litigants establish entitlement to fees by clear and convincing evidence. And in doing so, basically the court noted that patent litigation has always applied a preponderance of the evidence standard, and that there's no reason to do anything different in this context. And so obviously, you know, what a lot of people were wondering after that decision is how this would affect the number of fees motions that are filed, and then obviously the disposition of those motions. And not surprisingly, there has been an uptick in motions filed in the 2 years following the Octane Fitness ruling. The number of attorney's fees motions has increased by 56% in federal district court. Obviously, that varies somewhat from court to court. And then we also took a look at some of the more patent-heavy courts, and so we saw corresponding increases there as well.
So, Bill, real quick, before we move on to willfulness for attorney's fees, it seems that what judges are looking at, you know, they're going to be looking at from when the case started all the way through whenever the case, whether it's dispositive motion or successfully winning a trial. And, you know, I'll just kind of make a comment for everyone that you shouldn't start thinking about how you might move for attorney's fees late in the case. It needs to be something that is thought of as part of the initial case strategy based on your preliminary infringement analysis and based on the course of conduct from the plaintiff. If there are real issues with lack of due diligence, those should be noted, and a record should be developed early on that there are serious issues about the conduct of the plaintiff, and then also support that, buttress it with actual reasons why there's a lack of infringement basis, et cetera. And that's important because, Bill, I'm right, the judges are, you know, this is not a fee shifting type situation. You know, in the garden variety, just because you're successful doesn't mean you're going to get fees. in just a garden variety case. You really need to prove it up, right?
Right, exactly. And you hit the nail on the head that you really want to start establishing that record as early as possible. And we have a slide a little bit later on addressing demand letters, but it really does start with that initial analysis and being cognizant of that narrative throughout the litigation. And then later on, you're going to assess whether you actually have developed those facts and whether the conduct of the plaintiff was egregious enough where you can, where that motion is merited. So moving on to willfulness, earlier this year the Supreme Court overturned the test for awarding enhanced damages for willful patent infringement established by the Federal Circuit in the Seagate case. Under the Seagate test, a plaintiff seeking enhanced damages was required to prove both an objective and a subjective prong. Under the objective prong, the plaintiff had to show by clear and convincing evidence that the infringer acted despite an objectively high likelihood that its actions constituted infringement of a valid patent. If the plaintiff satisfied that prong, it was then required to prove subjective recklessness to determine that this objectively defined risk was either known or so obvious that it should have been known to the accused infringer. So in the HALO case, earlier this year, the Supreme Court essentially determined that this test was unduly rigid, and it rejected the objective prong of the Seagate test. And so then using this as a segue, in terms of demand letters for those who often find themselves on the defendant's side, you probably get a lot of these. And there's been a lot of discussion about how the HALO ruling and Octane Fitness ruling affect strategy here. Obviously, HALO was a pro-plaintiff opinion, and Octane Fitness was arguably pro-defendant. In the context of demand letters, it's only more critical now to establish a favorable record early on. In terms of strategy, it really is important to have, I wouldn't say a written policy, but at least some sort of informal protocol in place with respect to how to assess these situations. It doesn't necessarily have to be a policy for, precisely what you put in a responsive letter, et cetera. But you do need to be cognizant of the factors that need to be assessed. Obviously, you're going to assess early on the extent to which you want to involve outside counsel. Consider the potential plaintiff, including the type and the size of the company. You're going to be cognizant of who sent the letter, who they've retained, if anyone. And all of these are factors that will go into your potential response to that demand. It's also critical that due diligence be undertaken early on. And again, that might require retaining outside counsel, maybe obtaining formal, opinion from outside counsel. And obviously, it would be important to conduct this earlier in the dispute, and the extent to which those opinions, or at least those positions, can be conveyed in the responsive letter setting forth preliminary non-infringement, invalidity positions, might even leverage, the ruling in Octane Fitness and maybe some of the subsequent cases that are favorable maybe in your district. Include that in the letter as well to make it very clear, the bases for your positions, and effectively, to put the potential plaintiff on notice that, if you do have a strong defense, make sure that the potential plaintiff is aware of that as early on as possible. And then we have, I'm not going to get into these today. I think we're getting close to the end point, but we have some slides in the presentation on patent exhaustion, and which get into the Lexmark case, which was very recently granted cert, and basically it goes on to December 2nd, Supreme Court granted Impression Products petition appealing the Federal Circuit's en banc decision holding that Lexmark did not exhaust its U.S. patent rights when it sold its patented toner cartridges to customers in the United States subject to a post-sale single-use no resale restriction, as well as outside the United States. And that's actually a case that we're involved with and we'll be monitoring, and maybe we'll do another webinar on that as well. But we have quite a few slides on that for those who are interested. You can review that in the deck that we circulate later. And then just real quickly, just a pending legislation update. Now a whole lot has changed for those who've been monitoring the situation. In the House, you have pending the Innovation Act, which really addresses, there are a number of issues that it tackles, but one of the most significant changes that it would result in is substantially heightened pleading requirements. Basically, a plaintiff would have to include claim charts in its complaint. Then there are also some requirements in terms of venue and things like that. And then in the Senate, you have the Venue Act, which essentially would restrict patent suits to district courts where the parties are incorporated or where they have physical facilities. And so, this would, obviously this has been sort of a hot topic, and we had the TC Heartland case earlier this year, which I believe the Supreme Court granted cert on. But right now, I believe both of these acts are pretty much stalled at this point, and in terms of the new administration, we haven't really, heard any indications in terms of, how they might view these pieces of legislation, so we're still sort of in a wait-and-see posture here. So with that, I'll pass the baton back to Steve.
All right, great, Bill, thanks. And I think we're right up on the hour, so we want to be cognizant of everybody's time. Also want to encourage anyone who has questions and wants to reach out, feel free, please. I think on the slide, you see there's an email address, and also feel free to email me directly. It's just sbaskin@mayorbrown.com. And in closing, I just wanted to, we did this last year. We're going to do this on an annual basis, patent litigation focused on financial institutions. So if you have any thoughts or comments on things that you'd like to hear about the next round for next year, please feel free to pass those along as well. We look forward to that. And the idea here is we're dealing with issues that, there's seminars or webinars out there that are dealing with one-on-one or attorney's fees, almost in an entire hour. So our goal here today was to highlight issues for you to be thinking about and to take back. Maybe it's cases that you have that are currently active and ongoing, and maybe this has given you some thoughts and to go back and look at those and see how maybe some things that could be it could be doing, and also talking internally with your in-house teams to focus in on some of these issues, whether it's indemnity or whether it's just having an understanding of the CBM process, so when they're working with outside counsel, they can be informed. Also, finally, lastly, if anyone is interested, we don't want to fill anybody's inbox up unnecessarily. If anybody is interested in the PowerPoint presentation, one, it will be, I believe, accessible via via the website shortly. But also, I'm happy to send it to you as well in an email. So if you can send me an email, again at sbaskin@mayorbrown.com, we'll get that over to you. So hope everyone has a good rest of the day, and appreciate everybody joining. Thank you very much.